2023.
Welcome back. We're going to deal with Chapter 5, the dynamics of courthouse justice. Learning objective. We're going to have a general sense of who works where in the courthouse. Analyze the importance of assembly line justice. Describe why discretion is found in the criminal courts. Identify the principal actors in the courtroom work group. Also indicate why ethics is important to the American legal system. Contrast differing understandings of why delay is a problem in the courts. Discuss the strengths and weakness of speedy trial laws. Explain why law in action approaches to court delay are more effective than law on the books approaches. The courthouse and the people who work there. The courthouse is at a specific location. We're going to look at the buildings and the players involved in the courthouse. The courthouse and the people who work there include the courtroom, visitors' access, the judge's bench, the defense and the prosecution, the jury, defendants, deputies, and people that work behind the scene. In a typical courtroom, we have the spectators' arena, we have the jury box, the counsel, which will be the plaintiff table, and the defendant's table with its attorney, court clerk's table, the witness stand, the witness, the judge's bench, the court reporter's table and the court reporter, the jury room, the judge's chambers, and the bailiff to keep everybody safe inside the courthouse. Now, the courthouse and the people who work there, we continue again. Behind the scene, we have the managers. Under the managers, we have clerks of the court, such as the protonotary, register of probate, and clerks. We have the chief judges, also the court administrators. As a result of the ongoing violence in our nation, the courthouse has increased security. At the same time, they have to deal with changing technology. Part of what they're doing nowadays is having metal detectors installed at every access point to the courthouse. They also have surveillance cameras. Their goal is to make sure the courthouse security is beyond the courthouse itself. Even around the perimeter of the courthouse and the street before the courthouse, they have cameras all over there. Their goal also is to target violent offenders that may have other plans in mind. The dynamics of the courthouse justice. The first thing we're going to deal with is the assembly line justice. Strengths of the explanation. When we are talking about assembly line, look at it, for an example, a place where you make cars, like a general motor assembly plant. Here you have one individual that's going to install the door to the car. You have somebody that will lower the engine into the hood. Somebody will install the exhaust system. In other words, every person on the assembly line have a major task to perform instead of one person doing the whole thing, which will take a longer period, maybe about a month, to even finish installing a car. But with the assembly line, what you have is about 8 to 10 individuals doing a specialized task to speed things up, and they could probably finish a car in about 2 hours or less. And when you compare that to an assembly line of justice, let me correct myself. So what we have is a process where cases move through the court quickly. Each actors in the courthouse specialize in a specific task, speeding things up. What are the weaknesses of those? Everybody is doing the same routine administrative work every day there in the courthouse. It also fails to consider types of cases trial courts must decide. Discretion. Discretion is used every time a decision is made, from offense to sentencing. Discretion is about choice. We all make a choice of what we do. The courtroom work groups are mutual interdependent. In other words, everybody depends on one another. They have to work together. They share decision-making process. They socialize together. They deal with normal crimes in the courthouse every day. And they also deal with the rewards and sanctions that comes with working together. Variability in courtroom work groups. A problem in some jurisdictions, but may not be a problem in another jurisdiction. What are the consequences of delay in the court process? It erodes public confidence in the judicial process. It also violates the Sixth Amendment of the U.S. Constitution, which deals with the right to a speedy trial. Now let's look at the cost of delay. A delay in a court proceeding will force defendants to enter a detrimental plea bargain, can force prosecutors to offer lenient agreements, and when you delay a trial for too long, the defendant might skip court appearances and become a fugitive from justice. Law in action. When we look at law in action deals with case scheduling, efforts in coordination, variability in courtroom work groups. What do we have under law on the books? Law on the books is referring to some of the court individual right procedure guaranteed by the U.S. Constitution or your state constitution. Number one is the speedy trial law, and then we also have limits to what we can do as to speeding up a trial. Under legal ethics, it deals with the model rules of professional conduct and state codes. Ethics differ from morals, often requires to choose between a group of negative alternatives. When you look at lawyers, they have to protect their clients. They do not allow clients to perjure themselves. In other words, to lie to the court while they are on the stand, giving testimony. Highest court of each state is responsible for enforcing court's ethical guidelines. In other words, the Supreme Court of each state is responsible. And ladies and gentlemen, that's the end of chapter 5. It's a short chapter. We will now start chapter 6. Now, chapter 6 has to deal with prosecutors. We are going to discuss the two major characteristics of prosecutors in the United States. describe the three most important entities in the federal prosecution, identify the three somewhat overlapping agencies involved in prosecution in state courts, explain the major factors affecting the work life of assistant district attorneys, analyze the principal factors affecting prosecutorial ethics, outline two major examples of the expanding domain of the prosecutor. Now let's talk about the origin of the public prosecutor. They are considered government employees in civil service. It evolved from private prosecution at English common law. Private citizens facilitated private vengeance in the era. Concerns regarding due process about private prosecutions led to public prosecutor model. Quasi-public prosecutions. Prosecution outsourcing model, we'll talk about that, and part-time prosecutor model. Role of the prosecutor again. Major characteristics of the prosecutor. They have broad discretion. In other words, part of the executive branch of government, officers of the court are immune from civil lawsuit when acting as courtroom advocates. They make the charging decision. Under that, they have total discretion or choice of what kind of charges they could bring up against an individual. We will also deal with focus concerns theory and decentralized office. Let's look at prosecutor at the federal level. We have Solicitor General. It represents the U.S. government before the U.S. Supreme Court in all appeals of federal criminal cases. On the other side, we have the State Attorney General. He is the chief legal officer of the state. His job includes civil duties, more extensive than criminal duties. Has limited authority in criminal prosecution because every city have their own district attorney's office where they have prosecutor that will prosecute the cases. Criminal division. The Solicitor General prosecutes a few nationally significant criminal cases, and they also exercise nominal supervision over U.S. attorneys. On the other side, the chief prosecutors at the state level and their assistant, they have great autonomy in prosecuting felony cases, and they typically argue cases on appeal. Under the federal level, the U.S. attorneys and their assistants prosecute most criminal cases in the federal court, and they enjoy great autonomy in actions. At the state level, the local prosecutors often handle preliminary stages of felony cases. They prosecute the large volume of cases in the lower courts. The U.S. Attorney General, three most important entities. The Solicitor General is the third ranking officer in the Department of Justice. Criminal Division of the Justice Department formulates criminal law enforcement policies in federal cases. The U.S. attorneys, they are the principal litigator, as I said earlier, under the direction of the Attorney General of the United States. The U.S. attorneys are appointed and served at the discretion of the President with the consent of the Senate. There are three main statutory responsibilities. They prosecute criminal cases brought by the federal government. They initiate and defend of civil cases in which the United States is a party. They also engage in the collection of certain debts owed to the federal government of the United States. Prosecution in the state court. There are three overlapping entities at the state level. One is the individual state attorney general's office, chief prosecutor, and then we also have the local prosecutor at the local level. The prosecutor's office at work. They have assistant district attorneys, they work over there, and there's a high turnover at their level because most of these guys just came out of law school and working for the government, and once they have about 3 to 4 years of experience, they will leave and go to a private law firm or start their own law firm. Law schools provide little exposure to day-to-day operation of the prosecutor's office. And these guys are referred to as young prosecutor syndrome. Promotions and office structure. Experience normally leads to promotion. Supervision. They are supervised by a section head. Attempts at greater supervision. Representatives of both victims, prosecutorial ethics. Under there we have representatives for both victims and the police. Prosecutorial immunity. They are given absolute immunity within the realm of prosecutorial function. In other words, when they are doing their job. They also have what is called qualified immunity. In other words, when they are not acting as advocate for the government. Here are some of the ethics facing the prosecutorial office. Ethical issues different from those facing defense attorneys. Clients of the prosecutor is the government. Ethical issues facing prosecutors are disclosure of evidence, conflict of interest, discretion, and how much information to release to the public. Prosecutors and the courtroom work groups again. They all have conflicting goals and contrasting work groups. Political styles of each prosecutor might be different and with contrasting work groups. Socialization process also varies. The expanding domain of the prosecutor. They are there to improve police-prosecutorial relationship by promoting adequate police reports of crime or criminals, and there is plenty of contact between the two parties. Community prosecution. Under community prosecution, what's the goal of that? The goal of community prosecution is crime prevention in that particular community. And that's the end of chapter 6. Now let's go to chapter 7 of the test. Chapter 7. Now we are going to talk about defense attorneys. Learning objective. We are going to interpret the 4 major legal issues surrounding the right to counsel, discuss how the courtroom work group affects how defense attorneys represent their clients, explain why most lawyers do not represent criminal defendants, compare and contrast the 3 systems of providing indigents with court-appointed attorneys, recognize possible tensions between lawyers and clients, analyze the importance of legal ethics to the defense of criminal defendants. Let's look at the case of Gideon versus Wainwright, 1963. The plaintiff name is Clarence L. Gideon. He requested a court-appointed attorney and was refused. Unrepresented by counsel, Supreme Court sided with Gideon that he has a right to a court-appointed attorney. Indigent defendants have the right to court-appointed counsel. Applies in felony criminal proceeding. Decision, at that time, the decision sent shockwaves through the criminal justice system all over the United States in 1963. The right to counsel under the Sixth Amendment, it also extended to juveniles in the case of In re Galt, 1967. In re means in the manner of God. It deals with issue of right to counsel with non-felony criminal prosecutions, stages of the criminal process, ineffective assistance to counsel, and self-representation. Here are cases that deal with the right to counsel in a non-felony prosecution. The first case is Assasinja versus Hamlin, 1972, Scott versus Illinois, 1979, Alabama versus Shelton in 2002. Yes, cases that deal with the right to counsel at the stages of the criminal process. The Sixth Amendment applies to all criminal prosecution, thus coined the term critical stages test. And the cases involve Mempa versus Ray, 1967, Miranda versus Arizona, 1966. I know some of us remember your Miranda right, the right to remain silent, and so on. That's the original case. And the third one is Corby versus Illinois, 1972. Right to counsel once adversarial proceedings have begun. The cases are Brewer versus William, 1977, Rodri versus Gillespie County, 2008, Missouri versus Fry, 2012, Lafler versus Cooper in 2012 also. Right to counsel is granted under stages of the criminal process, such as custodial interrogation. That's 1966, Miranda versus Arizona. Police lineup in U.S. versus Wade, 1967, and Kirby versus Illinois. In other words, a lawyer has to be present for those lineups. Under ineffective assistance of a counsel, the court rule is based on what is referred to as objective standard of reasonableness. The case is Strickland versus Washington, 1974. Did the counsel conduct undermine the proper function of the process? Did they render the outcome of the case unfair? Appellate court must reverse if proceedings were unfair, and the outcome would have been different if counsel had not been ineffective. There are few appellate court reversals on these grounds. Self-representation. Defendants have a Sixth Amendment right to self-representation. The cases involve Pro Se, Missouri versus Fry, 2012, Lavla versus Cooper, 2012, Faretta versus California, 1975, and Limit. must show judge the ability to conduct the trial, and standby counsel is always available to them during the trial. Defense attorneys at the courtroom work group. How do we define winning when it comes to defending your client? Winning should be defined as doing the best you can possibly do for your client. Either you're trying to argue for probation, accepting a plea to a misdemeanor from a felony, assuming your client is guilty. Defense attorneys and the courtroom work group. Cooperative attorneys reward access to police reports if they all work together and witnesses, and attorneys can be sanctioned for indirect poor scheduling, dragging out of trials, and then under direct criticism, lack of assignment of some cases, which might lead to tougher plea bargain for the client. Variations in cooperation. Inexperienced attorney, gamblers, public defenders, private attorneys with large numbers of defendants, and assessment co-opted or cooperative with the rest of the courtroom work group. The criminal bar, the diversity and the stratification of the legal profession, environment of practice, low status, difficulty in securing clients, and low fees for them. Providing indigent with attorney, appointed counsel, indigent. Indigent, those are too poor to pay for an attorney and are entitled to have one provided for them for free. 3/4 of state prison inmates have a court-appointed lawyer. In urban courthouses, 82% of felony defendants are too poor to hire their own lawyer. It is up to counties to determine what type of system they will utilize. 3 systems of assigned counsel of providing indigent attorney. One is assigned counsel, attorneys appointed by the judge or on a case-by-case basis. Another one is a contract system, attorney hired to provide services for a specified dollar amount. Public defender, they are a salaried public official representing all indigent defendants. Most assigned counsel, they are very common in small counties. The criticism is that they are least qualified attorney and inadequate pay. Contract system, most common in small counties. The criticism is a lower standard of representation due to bidding. Private bars no longer plays an important role in indigent defense, and found unconstitutional in Arizona. Public defenders, Los Angeles County in 1914. Today, the public defender system represents approximately 70% of all indigents nationwide. Public or private, non-profit organization representing clients and indigents. Funding occurs at the state or local level. Public defender, the proponents, they say we need to devote more attention to clients, more experienced, competent counsels, continuity and consistency. Criticism of the public defender, they are tied too closely to the courtroom work group. Lawyers and clients. Lawyers act as advocates and counselors. Privileged communication exists between the lawyers and the client. Some of the frustration they are getting from their client may be due to lack of trust, evasiveness, deception, and failure of their client to take advice. Defendants' view on their lawyers, they see their lawyers as skeptical about skills, worry about whose side their lawyer is on, very suspicious of their lawyer, and lack of one-to-one contact. The model rule of professional conduct for defense attorney, in other words, the ethics, they are duty bound to be candor to the client, refrain from making any out-of-court statements, zealous representation, abiding by client's decision, act with reasonable diligence, confidentiality, and lastly, avoid conflict of interest. And ladies and gentlemen, that's the end of chapter 7. Now let's start with chapter 8 of the textbook. Judges, chapter 8. Learning objective. Discuss the role of the judge within the courtroom work group. Name the 3 major ways that judges are selected in the United States. Analyze the consequences of different methods of judicial selection. Recognize major changes in the composition of the bench over the past several decades. Describe the activities of state judicial conduct commissions. Explain the difference between the impeachment and the removal of a federal judge. Powers of a judge. Arrest through disposition. They set and revoke bail. They preside over trials, and etc. Benefits of the job. They are often make big salaries, can appoint friends to various positions. What are the frustrations of the jobs? Heavy caseload, administrative problems. They are called a politician, administrator, bureaucrats, and lawyer all in one. Judges within the courtroom work group, constrained by actions of others, sanctions, and transfer. They are the most powerful member of the courtroom work group. They could offer verbal rebuke, use of power varies, and some attorneys like to do what is called judge shopping. In other words, looking for a favorable judge, leaning towards them. Varying roads to a judgeship. Some got their job through executive appointments, and some through partisan election. In other words, belong to a party like a Democrat or Republican, and some got to the job through a non-partisan election. And then we'll also look at the merit selection of judges, and this is the one referred to as the Missouri Bar Plan. Executive appointment in federal branch. Article 3, judges are appointed by the President and confirmed by the Senate. Deputy U.S. Attorney General nominates judges with advice of high-ranking official, usually seeks ABA recommendation. Executive appointment in the states. Governors nominate those active in their campaign, and They also seek advice from ABA, in other words, the American Bar Association, the organization that the lawyers belong to, and judges too. Election of judges. More than half of all states elect judges. This concept emerged during the Jacksonian era. It was part of a movement to democratize the political process. Some elections are partisan while others are non-partisan. Voters can be uneducated and disinterested. Few lawyers wish to challenge a sitting judge. Recently, judicial elections are getting more unpleasant. Then we have the merit selection under the Missouri Bar Plan, and then retention election once they are put forth meritoriously to serve as judge in a court. Now the question is, which system is best? Does one system produce better judges than the other? Similarities in judges' background: white, male, Protestant, highly educated, upper middle class. Diversity in the judiciary. We have female judges now, non-whites, both Republican and Democrats, are now integrating into the courtroom. How do judges produced by one system differ from judges produced by another? Makes a difference if you want to be a judge. If appointed by legislatures, more likely to appoint former legislatures. Elective system produced judges who were formerly local politicians. Different systems still often produce judges that have similar backgrounds and characteristics. Elected judges react to public opinion most of the time because they are there to run again after the original term expires. In other words, run for re-election. Similarities in background. In general, like I said earlier, male, upper middle class, white, Protestant, educated. Increasingly, judges are starting to look or resemble American electorate. Increasing diversity in the backgrounds. 25.3% of federal judges are women. More votes from presidents towards judicial seats are for women. 29% of all state judges are women, 6.4% of African American, 3.27% of Hispanic, and 1.3% are Asian American. More women and minorities are being appointed as federal judges. Today, 37% of federal judges can be considered non-traditional. Attempting to draw conclusions about the difference women make on the bench is problematic. Studies of female judges show strong support for women's rights claims, harsher sentencing, particularly repeat minority offenders. Judging the judges. Judicial independence is a matter of facts. How to remove unfit judges without compromising judicial independence. Judicial performance deals with judicial performance and evaluations of judges. Under there, we have the Judicial Misconduct, and the Judicial Conduct Commission oversees any judicial misconduct. Federal Conduct and Disability Act allows for impeachment and removal of judges. Judicial ethics. Additional ethical constraints beyond those of lawyers. The American Bar Association model canons of judicial ethics deal with them. Each state has a set of canons of judicial ethics. And ladies and gentlemen, that's the end of chapter 8. Next time, we will start on chapter 9 of your textbook. And this just happens to be a short slide.